Hello! Today I will try to analyze the ad blocker softwares in a legal context. Let's start. Ad blockers are basically content filtering mechanisms. Most popularly, they could be used as browser plugins or web browsers which already have blocker integrations. Another popular method is DNS, domain name system filtering, or local VPN, virtual private network softwares, which filters not only your web browser but your all applications, your computer's full data flow. And also there is another method which is your internet service providers ISPs on external filtering or another external devices like routers. Whatever method you use, the procedure is the same. There are filter lists that are updated by the provider regularly, and the lists catch the HTML objects that contain ads. When you enter a website, all the objects that fall into these blacklists get removed. As an option, it's possible to have whitelists to exclude some websites from filtering. So what could be unlawful in ad blocking? First of all, as a visitor, nobody has to view all the contents that the publisher put into the page. You can always filter any content since these are your own HTTP requests in your own web browser. There is nothing violating the publisher's own property. However, I must say that this approach is mostly from the European Union, which prioritize data subjects' rights rather than the Americans, who might have more strict perception of property and less strict about prioritizing data subjects' rights. However, when the website has a terms of use or terms and conditions, which is kind of a contract between publisher and visitor, and if the terms of use explicitly says that ad blockers are not allowed in this website, if you agree these terms of use and continue to use your ad blockers, it might be considered as a breach of contract, maybe, even though it's impractical for publisher to determine this breach and take this case into the court. But what about the ad blocking software developers? We talk about the users, the visitors, but what about the software developers? There are some court decisions from Germany and that majorly reflects the European Union's perspective about ad blocking. IO, which is the company developing one of the most famous blocking softwares, which is AdBlock Plus. The company is sued by the publisher companies many times. Since today, the defendant company IO won all of these trials. German court's approach is clear. There is nothing violates website owners' intellectual property. It is a legitimate right to make blocking mechanisms that filter users' own HTTP requests. However, in terms of competition law, there is an interesting controversy about whitelist feature of ad blockers. As I said before, whitelisting means that excluding some websites from the filters. Our claimant is Axel Springer, which is one of the biggest publishing companies in Europe, in Germany. Defendant is again the AdBlock Plus, the IO company. Springer claims that a website owner who doesn't want its website to be filtered by ad blockers pay money to the ad blocking companies, and this is against the competition law. Even though the court of first instance decided in favor of claimant Springer, Supreme Court's final decision is in favor of AdBlock Plus. But I think it's open to discussion. Okay, let's move towards the website owner's revenge, which called as anti-ad blockers. When publishers want to get rid of ad blockers and protect their advertisement revenues, they can set up these scripts on their web page. These scripts detect ad blocking and the publisher can use them in three different ways. First scenario, when visitors' ad blocker usage is detected, a message shows up and says, okay, I know you're using that software. I won't force you, but I need some income to maintain this website. Please, I request you to close it. The other two scenarios, though, are not that liberal. One is forcing visitors to disable ad blocker or disallowing them to enter the content. The other one is offering another choice: subscribe the website by regular payments or disable the ad blocker, otherwise disallowing visitor to access the content. I must say that second and third scenarios are compulsory. In other words, usage of an ad blocker is explicitly disallowed by publisher. That means if I find a way, like anti-ad blocker, to bypass website protection mechanisms, it is called as circumvention. According to anti-circumvention law, which is based on WIPO's copyright treaty, this action can be considered as the violation of copyrights. USA's Digital Millennium Copyright Act, Turkey's Law on Intellectual and Artistic Works, and the directives of European Union are legislated in regard to WIPO's treaty. But let's have a further question. Could an anti-ad blocker itself be against the law? This controversy is based on EU's e-privacy directive, which have provisions for regulating the storage and retrieval of personal data, therefore providing a condition of data subject's consent. The claim is when these scripts detect the data subject's usage of ad blocker, they collect some personal data without data subject's consent. For this reason, this mechanism is unlawful. However, the anti-ad blocker software developers have their counterclaim. They say that these scripts have no permission to read personal data. In other words, they actually don't detect which software is used by the visitor. The script is basically check whether the ads are delivered to visitors or not. It is totally irrelevant to storage or retrieval of data subjects cookies. And now, what's next? As we see, there are controversial points regarding to ad blocking issue. There is still no specific regulation about this conflict of interest. Considering this conflict's significance in global internet, standardization seems necessary. Subscription options and more empathically usage of anti-ad blockers are good developments, but not sufficient. There are some other independent committees which try to determine a standard for web advertisements. Acceptable Ads, coordinated by AdBlock Plus, is one of them. Another example is the Coalition for Better Ads, and their advertisement standards are already integrated in Google Chrome's new ad blocker feature. These organizations aim to protect both publishers' income and user experience by whitelisting advertisements that are not that disturbing. However, their independence and their subjective standards are still open to debate. Therefore, it looks like these controversies may continue in the upcoming years. Thanks for listening.